Okay, everyone.
Hey, good afternoon.
Yeah, we'd want to thank Winston for being here. And for those of you who don't know, Winston is our civil rights specialist that works for ODE and consults with all of us on making sure that we are in compliance with ADA, 504, all of those kind of things. And he is a wealth of knowledge. He also teaches some courses, I hear. So we want to thank you, Winston, for taking the time out of your day. That's probably very busy, I would imagine, to talk with our group. So with that, everybody welcome Winston. And Winston, the stage is yours.
Great, Melissa. Thank you very much. Welcome, everybody. I appreciate you braving the snow and joining us. Again, I'm with the Oregon Department of Education. I'm part of the Office of Equity, Diversity, and Inclusion. And one of my responsibilities is to be the state 504 and ADA coordinator for the field. So I am indeed someone that's available to you to speak around this. So we're going to spend time talking about 504, Title II of the ADA, and students with TBI in public schools. And I'm just trying to move my slide. All right, so again, our objectives today are twofold. We're going to talk about the requirements of Section 504 and Title II, and our focus is explaining the responsibilities of public schools in educating students with disabilities, and in particular TBI. There are a number of keys in talking about 504 and the ADA. 504 is a law that was originally introduced in 1973. It's been amended by Title II of the Americans with Disabilities Act in 1990, and then amended with an Amendments Act to the ADA in 2008. So the first piece is that the U.S. Department of Education Office for Civil Rights considers 504 as a general education responsibility. So 504 students are predominantly students in regular education settings receiving accommodations from classroom teachers or related benefits and services from ancillary school personnel. The goal is to make the school environment more accessible. And of course, given that these are civil rights laws, our ultimate goal is equal opportunity. It's important that 504 team members have specific knowledge and contribution. One person must be knowledgeable about the student. Another person needs to be knowledgeable about the evaluative criteria. And then the third person needs to be knowledgeable about the placement options. A key in 504 evaluation is that no single source decides in any aspect. So we're constantly looking to triangulate. We're constantly looking for a group consensus or 504 team decision making. Our goal is to provide students with timely and effective accommodations. Something that's important in today's 504 are episodic and in remission conditions are in play. This is a change from the past and took place in 2008. When we look at TBI, and on the CBERT website, they talk about this in some of the literature, is that the medical issues that are related to TBI that are likely to be ignored because sometimes they're not visible to us. These are things like fatigue or sleep issues or headaches. And then the last thing is for 504 students currently, we have no mitigating measures except for eyeglasses. In the past, if a person received medication or received some other type of accommodation, we could consider those measures in determining the substantial limitation. Now we're supposed to consider the student as though the student did not have those mitigating measures. 504 prohibits discrimination on the basis of disability. by schools that receive federal financial assistance. Title II extends that prohibition of discrimination to all public schools, including public vocational schools and public charter schools. For the purposes of 504 or the ADA or any equal opportunity law, a public charter school is the exact same as a public school district school. We're going to begin to focus on what school districts and related people need to know about 504 and Title II. 504 has a child find responsibility. So every year, each district must identify and locate students with disabilities in the district who are not receiving a public education. So this is through announcements in newspapers, common meeting areas, public service announcements, could be social media. And the district has a duty to notify parents and guardians of children with disabilities of the district's duties under Section 504. A key objective in dealing with Section 504 and the ADA is to provide a free, appropriate public education. The acronym is FAPE. We're providing this FAPE to each qualified student with a disability. Here's an important piece wherein it says in the school district's jurisdiction, because this piece includes students in private schools. Our public schools have a duty to evaluate students who are in private schools. So if we have a private school student and they come to the school district that is their residential school district and say, my child has TBI and I'd like my child evaluated for a 504 plan, the district has a requirement, is required to evaluate that student for a plan and to make a determination as to whether or not the student would receive plan accommodation if the student were to attend the district either full-time or part-time. What we're asking school districts in Oregon to do, and a number of them are choosing to follow this guidance, is we're actually, if the team determines that the student would be eligible in the public school setting, we're actually asking them to write the 504 plan and provide it to the parent, in effect saying, if your child attended our school district or our school, this is the plan we would offer and these are the specific accommodations we would provide. This is an opportunity for families who attend private schools to get some information to take with them to the private school. The last piece is that we provide FAPE regardless of the nature or severity of the disability. There's a provision in 504 and the ADA around undue financial hardship or undue financial burden. Undue financial burden does not apply when it comes to a student's education. Let's talk a little bit about what free and appropriate mean. Free literally means free. So there's no charge for any costs related to a disability. Schools may charge usual fees paid by all students. Let me give you an example. We have a student with TBI who wants to be part of the speech and debate team. The speech and debate team receives tablets to prepare its information for their contest, for their meets. The student with TBI experiences headaches, and when the student experiences headaches, the student has difficulty reading. So for this student, the team decides that they need to put a screenwriter or provide audio-based material on the student with TBI's tablet. That audio material costs $100 more than the $50 the district charges each student. The student with TBI would pay $50 just like his or her peers, so they would not be charged any cost related to needing the audio for their condition. An appropriate education refers to placement, and it's basically providing either regular or special education and related aids and services that are designed to meet a student's individual needs as adequately as the needs of non-disabled persons are met. So when we look at 504, we're looking at things comparatively. So in 504, we're constantly looking at our student with the condition and how does that student with the condition compare to the average student. So our process is threefold. We need to identify students, then evaluate them, and if the evaluation reveals that the student needs plan accommodation, provide placement. Districts must individually evaluate any child who, because of a disability, needs or is believed to need accommodations or related services. The purpose of the evaluation is twofold. Our first concern is, does the child have a disability under Section 4 or Title II? And if so, then what are the child's individual education needs? This is, in effect, what the question we want to answer. This is kind of what's called the three-prong test for 504 accommodation. Does the student have a physical or mental impairment? That's one prong, which substantially limits, that's the second prong, one or more major life activities. This is where 504 is extremely inclusive. So 504 defines an impairment as any physiological condition that affects a bodily system or any mental or psychological disorder. And this is where we begin to see language in 504 and the ADA that says this definition is non-exhaustive. So it means that conditions can be added. So there may be conditions with which we're familiar. There could be conditions or attributes with which we're unfamiliar. That's not really for our evaluation. The next question we'd like to answer is, does the student's impairment substantially limit one or more major life activities? This is a list of major life activities. So if you notice here again, this is that non-exhaustive list where it says, but are not limited to. If you look in the left-hand column, those are the original major life activities that were in law in 1973. So as you review those, you can see in education, the second from the bottom, learning is one of the key major life activities for us that was in the initial law. In 2008, the accommodations, the major life activities were extended. And this is where we see some major life activities that are very specific to students with TBI. There are three if we're looking from the bottom of the list up. I'm looking at third from the bottom, thinking, concentrating, and reading as major life activities that would clearly impact a student with a traumatic brain injury. There may be others on the list for your students as well. In 2008, they also extended the major life activities into a category that was called the operation of major bodily functions. If you look in the right-hand column, you can see that brain as a bodily function or neurological bodily functions also are considered major life activities. So there's no question when we have a student with TBI that that student may be qualified for a 504 plan. I'd almost want to stop here and say that one of the things that we've been advising Oregon school districts to do and Oregon District 504 coordinators is we've listed TBI with a number of other conditions that we have strongly encouraged our school districts to consider for 504 accommodation. Those other conditions, by the way, are insulin-dependent diabetes, so all type 2 diabetics and some type 1 diabetics, epilepsy or any life-threatening seizure disorder, and we define life-threatening as having a formal emergency protocol or a 911 emergency protocol plan. We do the same for any student who has a life-threatening allergy. And then TBI is the fourth one in that list of things, of conditions, where we've said to our district, we really want you to consider these students for 504 accommodation. And our professional opinion is if you were to decline to do so, the burden of proof would be on the district to demonstrate why it declined to offer 504 accommodation. The third prong, and this is probably the most important prong for school district 504 teams to consider, is how substantially limiting is the condition for the student. What it says specifically in the law is that it does not mean that the student is severely restricted or has an inability in performing a major life activity. Another way to think about this is, one, comparing it to the average student. Is our student with TBI limited in performing a task as compared to the average student? Or the flip side would be, could the student with the TBI condition perform the task without the accommodation? And if the answer to either of those, if the student is limited compared to the average student or cannot perform the task without the accommodation, those are strong indicators that the student is substantially limited. I want to talk briefly about the second bullet where it says look to condition, manner, and duration. Historically, 504 has asked districts or providers to consider persons who may have a temporary or an intermittent condition as not qualified for a 6-month period. That attitude or position has changed. So if we have a student who may have a condition that may be of short duration but is extremely severe for the short duration, that's a student we still want to accommodate and put on a plan. If we determine that the student is qualified based on those three prongs, then we want to begin to determine what are the child's individual education needs. Needs are identified by looking to a variety of evaluation sources, and this is a cumulative file review. So we begin to look at aptitude and achievement tests. Teacher recommendations are extremely important. Physical condition, social or cultural background, adaptive behavior, among others. Once we evaluate the student and we establish eligibility, and the student's specific needs have been identified, we then need to look at placement. Placement is essentially appropriate educational services designed to meet the student's individual needs. Who decides the placement? We talked about this briefly before, but it's a team that is a group of individuals that includes persons who are knowledgeable about the student. That's usually the student's classroom teachers, the parent, or possibly the school counselor. The meaning of the evaluative data, that may be the school counselor, it may be a school psychologist, it may be a physician or provider, or the placement options. And the placement options are usually known by the 504 coordinator or the counselor or a school administrator. The placement team has to carefully consider evaluation information from a variety of sources. At the outset, we said no single source determines everything, so we're constantly trying to triangulate. And it's an imperative of the 504 team that it consider all significant factors affecting the student's ability to receive a free, appropriate public education. The 504 team should be documenting all of the information that it considers, and it should clearly not be relying on assumptions regarding persons with disabilities or classes of such persons. A 504 evaluation or review is very much individualized. So one case could be different from another case, but both students may qualify for accommodation. It's funny, usually when we do these presentations, we talk about 504 accommodations in a very general way, but Siebert has an outstanding list of 504 accommodations for students with traumatic brain injury. The list of accommodations I looked at was on the Siebert website in its TBI tidbits. And this one, the one that I pulled out, was from January 13th. And I've just given you the overarching categories, but in each of these categories, Siebert lists anywhere from 7 to 10 specific accommodations, and they list it really well in a checklist form that parents or even teachers can look at. So included in this list are processing delays, memory deficiency, visual or spatial deficits, fine motor difficulties, gross motor difficulties, mobility, fatigue, attention, organizational skills. And organizational skills has been cited recently by the U.S. Department of Education Office for Civil Rights as skills that 504 teams must consider for students. They mention this in the Dear Colleague letter that focuses on ADHD, attention deficit hyperactivity disorder, but this is clearly, in my professional opinion, applicable to students with TBI. Academic progress, emotional well-being, behavior, transitions is very important, and use of technology. 504 students can be placed in several different academic settings. First and foremost is regular classes. Second is regular classes with supplementary services. And what's interesting is 504, which is the predecessor to IDEA, also includes special education and related services. Generally in Oregon, when we offer students 504 accommodation, we're offering those predominantly for the first two bullets, for regular classes or for regular classes with supplementary services. In extenuating cases, those students may also need special education services. Once the educational placement has been decided, one of the most important things we need to do is implement the plan. Everyone involved has to remember that a 504 plan is a contract. It is a binding contract, and that all parties must be held accountable for the accommodations for which they're responsible. It's real important to note that if accommodations are not being implemented, that we really have to get back to the building coordinator or to the building administrator to let them know that accommodations are not being implemented. What I've suggested to building coordinators is that they speak to the individual who is not providing the accommodation to make sure that the individual has clarity about the responsibility and the actual implementation of the accommodation. They should only do that one time. If the individual fails to respond and fails to provide the accommodation, we need the coordinator to contact that person's supervisor. I believe that this is a very serious matter. In Oregon, all of our licensed personnel, when receiving their certification, agree to an ethical standard. They can violate that ethical standard in two ways. One, either by engaging in gross misconduct, or two, grossly neglecting their duties. I believe that a failure to provide a 504 accommodation is a gross neglect of duty. 504 students should receive periodic reevaluation. Periodic is a term that the law uses initially. What's best practice is annual evaluation, and it's really important to consider annual evaluation. What would happen if a school district were reviewed for any type of problem or issue with the plan, if it were determined that the school district didn't provide annual evaluation, the burden of proof would be on the school district to demonstrate why it didn't provide annual evaluation. The other bullet that's equally important is before a significant change in placement. A significant change in placement is a change from one school building to another school building within the same district. So that could be a student moves from one middle school to another middle school. It's clearly the change between elementary and middle school. That's a significant change in placement, and between middle and high school. We need to be very cautious with the change between elementary and middle schools. This is where we see significant disconnects at times, especially very early in the first year of the middle school experience. A parent and a student were interacting with a relatively small 504 team in the elementary setting. Obviously the number of teachers and providers expands 6 to 8-fold when we get to middle school, and sometimes there is a lack of coordination, a lack of awareness, or even sometimes a lack in attitude. And so we must be aware of these transitions from elementary to middle and middle to high schools. School districts must provide a system of procedural safeguards regarding identification, evaluation, and educational placement. The procedural safeguards usually appears on a sheet of paper. It's generally numbered 1 through 18 or 1 through 21, and it talks specifically about the identification process, the evaluation process, the placement process. It provides information on notice. It talks very specifically about how the parent or guardian can review records, and it talks about the rights and privacy of those records. The procedural safeguards also talks about due process. If a parent or a student is dissatisfied with the process or procedures regarding the 504 plan, that individual can receive an impartial hearing with participation by the parent and school district, or the parent and council. And then finally, the procedural safeguard speaks to review or evaluation procedures. There are common compliance concerns in providing a free, appropriate public education. One of the first ones is making decisions unilaterally instead of by the team. Sometimes this happens when the team is experiencing challenges in meeting consensus, and someone comes in from the outside and usually says, that's it, The team can't make the decision. I'll make the decision for them. That's one example of unilateral decision making. The other example could be in a circumstance where one person has a particular set of knowledge, or one person might have bias, and that person makes a unilateral decision or really imposes his or her decision-making will on others. The second common compliance concern, it regards making decisions that are not based on evaluation information or the child's needs. The third one, and we mentioned this before, is failing to implement the 504 plan. That's arguably the most frequent FAPE concern. And then the fourth one is not affording parents their procedural safeguards. We'll talk briefly about other responsibilities and then conclude. Something that's extremely important is that 504 plan and accommodation extends to all aspects of the student's experience and relationship with the school. So students with disabilities must be provided an equal opportunity to participate in transportation, lunch, recess, physical education, clubs, athletics, drama, student government. Any part of the school experience is an opportunity for the student to participate. And if the student needs accommodation in any extracurricular experience, then the 504 team must consider that and provide it as appropriate. Something that has come up recently with 504 plans and providing accommodation for extracurricular activities, and I think about this in athletics, is when I went to high school, all of my athletic coaches and advisors were full-time staff members. So they clearly had access to my records and my CUME file and my 504 plan. We're having experience now where we have more coaches and more advisors who are part-time or contract employees with the district. The district and the 504 team and the building 504 coordinator must have a clear plan to, one, train those individuals on 504 in general, two, inform those staff members that students in their programs have 504 plans, and three, ensure that those individuals are able to implement the accommodations within the plan as it applies to their extracurricular activity. And again, these extracurricular activity accommodations really should be a part of the 504 plan. We have to remember that 504 and Title II are discrimination laws, and denial of FAPE is only one form of discrimination. Other forms is providing different treatment or placing the student in a position where they have disparate or different impact from their educational peers. What we have to remember when we're dealing with civil rights or equal opportunity is our intentions never trump the impact on the student. So we may be well-intended in planning or evaluating, but if it causes adverse impact for the student, we have to look through the eye of the beholder, and we have to look through the lens of the person who's impacted adversely. Another really important area is disability harassment. I can see students who have TBI who may have conditions that make them either less active or less lucid in the moment, or if they have issues with attendance, experiencing teasing from their colleagues or even their faculty members. We need to be really clear and really deliberate anytime we get any signal of any form of harassment, but in particular harassment that's related to a school student's condition. Third aspect of discrimination is if an entity, a school district, provides significant assistance to any partnering entity that discriminates. So we almost need to be cautious if a school district is using an outside provider for evaluation and that outside provider has certain views on students receiving accommodation that don't favor a free and appropriate education, then that may not be the provider to use, and that may be the place where we may have maybe unintended, but still significant assistance to an entity that discriminates. Finally, any type of exclusion, denial of benefit, or other form of discrimination is an issue and must be prevented, and if it occurs, must be eliminated promptly. This is where my conversation with you or presentation with you concludes. My contact information is there. I encourage you to call me at any time. Again, I want to thank Siebert for the opportunity to present to you, and I'm eager to hear and respond to your questions.
So if anyone has any questions, now's the time to put them in the chat section, and we'll give you guys a few minutes if you're wanting to do that. Otherwise, we will end at that point. So I think I'll keep Winston on for a couple minutes and see if anyone has anything to ask. So far, Winston, we have a great job. I sincerely thank you for this presentation. Somebody saying no questions here.
Thank you very much. Thank you both.
Okay, so I will leave it at this. And for all of you guys, you can always contact Winston with questions, and you can always contact me. If you contact me and I don't know the answer, I'm going to go to Winston. So everybody, please feel free to do that, and please share with other people that we're both available to help and support with anything you need when it comes to this kind of thing. And before you get off, thank you all for all the great work you do. You're very, very appreciated. So I'm going to stop recording at this point. And yes, we will be sending the handouts to everybody. Thank you, Agnes, for that.